Can you hear me? Thumbs up? Okay, all right. As long as we don't have any other issues.
Thank you.
Okay.
Thank you, Your Honor. And I wanted to make certain no objections, Mr. Frank.
Yes, Mr. Steele, what is it?
On the PowerPoint, I'd like you to grab the newest one, I got the last one. Number 19 is argumentative. Number 41 through 47, 51 and 54 is the law that they take from the court. I would object to those numbers.
And Your Honor, I believe that the argument about the law was raised prior to lunch.
Hold on. As it pertains to number 9, I'm going to mark the state's second PowerPoint as the next court exhibit in order.
Yes.
In terms of number 19,
That is,
we didn't chase the lyrics to solve the murder. We chased the murder and found the lyrics. Is that what you expect the evidence to show, madam?
yes, it is.
All right, I'm going to overrule that objection. What's your next one, sir?
41.
41. Judge's rules. All right, this is a note taking that I already gave them.
Didn't change it.
Ms. Lowe, why are we rehashing this since I've already told them that?
Your Honor, why are we putting it
Why
back?
are we rehashing that? I just told them that. I told them what was in 41, as well as 42.
Your Honor, I can take them out. I don't mind. I was just, it's part of the opening that I wanted to emphasize, but I can take it out.
I'll sustain it. You can tell. I mean, you can tell them that.
Okay.
Fine. I'll ask that you take out 41 and 42. So I sustain that objection, Mr. Steele.
So
What about 49, 43? Did you have an objection, sir?
Correct.
Your Honor, is the court directing me to take out the picture, or can I just take out the word take notes? Because
Oh, no, take notes is fine.
okay.
He didn't object to that.
Okay.
He's objecting to 41 and 42, which I'll sustain the objections to that. And then 43, let me look at.
Okay, I'll take that out.
Okay, I have not instructed them on how to judge credibility as of yet. So 1 through 7 would not be appropriate at this time.
Okay, so,
But you can leave in bullets 1 and 2.
okay, so is Is
You
it-
must remember in any way that works for you what they said on Wednesday. That's fine.
Okay,
And you use whatever memory aid you need, just not to remember what you heard, but to remember who said it and how credible you found them to be when they testified, or some words to that.
okay,
But the other things, I have not instructed the jury as of yet on how to judge credibility. I didn't give them a preliminary charge on that. So if you could take those out,
okay.
1 through 7, please.
Yes, Judge.
Does that suffice, Mr. Steele?
And as,
Or do you still have an objection to 43?
And I appreciate what you said, I will accept it, but the prosecutor openly said this is Johnson versus State 261 Georgia Appeal, 98 Division 6C as in Colette
Charlie,
and Charlie.
no, just one, Charlie, okay?
I heard Colette.
Just one. We gave you the military alphabet. It's on your desk.
No, I have it. That's why I say and Charlie.
No, I only want the military alphabet, okay?
Colette is not right.
I know. A very sweet lady, okay? All right. So,
But it says the prosecutor's opening statement should be limited to what the prosecutor expects in evidence to prove a trial. So I don't see why the law is coming into their opening statement. That's my objection.
I removed 41 and 42.
for clarity's sake, Your Honor, I did and have been editing as the court has directed. So my 41, because I took out a whole slide, may be different. For clarity, the one that the court is referring to is 41. Is that the one where we are saying your assessment of a witness's credibility, blah, 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 all of that?
No transcripts in the jury room.
Okay.
I've already told them that too. So why don't you just do this?
I can take that.
Why don't you just your last slide can be take notes, and you can tell, I think that what you told them, what $43, sir.
Okay, as long as it's removed, then yes, I accept.
Okay.
Your Honor, and I want to make sure that we all have everything the same. So just to be absolutely certain, I'm going to share again with the court, because the numbers that I just heard the court reference.
I have the new slide show you sent me, which goes from 1 through, I didn't go down far enough. Okay, all right. The new slideshow goes 1 through 56.
56. I took out some, yeah.
So I'm going to say take out 41, 42, 43.
And I'm changing them in real time, so I'm taking them out. 43.
You need to take out 44.
Okay. Is that the one that starts with judge's rules?
No, please pay attention. You need to take out 41, 42, 43, 44, 45, I will leave in over objection. Okay. I'll let you leave in 45 and 46 over objection. 47, judge's rule, 47 needs to come out.
So the one about with the finger pointing, that,
Finger in the eyes are fine.
okay. And I took out judge's rules.
I got 47.
And I think I've already taken out 47.
47 is judge's rules again.
I took that out.
Any further objections, Mr. Steele? Because I am going to leave in 45 and 46, okay? But I'll take out the other ones that you just mentioned.
Okay.
So waiving my mistrial, thank you, sir.
Say again?
I apologize. Without waiving my mistrial, thank you, sir.
And your motion for mistrial has been denied, and I've noted your objection for the record, sir.
And confirming everyone has 1 through 52 with the edits that the court has directed.
It's on the same old list, right?
Yes, it is.
All right. Anything further? All right. Yes.
Just don't want to get an objection to the opening charge. We can do that later before we break for the day.
What are your objections, sir, to the court's, the court's preliminary instructions?
First, the court talks in terms of guilt and innocence. And I would object to any of the phrases that you use to determine guilt or innocence. I object to the use of the phrase, the purpose of the trial is to discover the truth. No, it's not. The purpose of a trial is to determine whether the state proves beyond a reasonable doubt the allegations in the indictment, so I would object to that. I object to the fact that the court, I believe, is going to allow the jury to frame questions to provide to the court. I was unaware that the court was going to.
I'm probably not going to do that, Mr. Steele, but Mr. Harvey. I do that because that's part of the pattern charge, the pattern preliminary charge. And most of 9/10 of the time, they're not going to ask any questions. And if they do, I will then present that question to you all for your consideration, and I may or may not ask it.
Okay, well, I have
But you objected to it.
I object to the process of
Okay.
Sixth Amendment.
Anything else?
State Constitution. No objection.
Okay, all right. And I'll note your objections for purposes of the record, sir. Okay, all right. Can we summon our jurors, please?
I go ahead and share.
Yeah, put up the last slide. I believe that was Mr. Ryan.
Okay. I'm gonna go back to Zoom. This is Zoom. Did you just send it? Has it come? It has come. Okay. Okay. One second.
Oh, ladies and gentlemen, please be seated. We're just going to wait on one. Wait on one. We're waiting on one juror, ladies and gentlemen. Just be at ease just a second, please.
I'll do the president.
All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, how was your lunch? All right, good, good. Okay, ladies and gentlemen, before we go ahead and continue with the state's opening statement, I need to kind of just advise you of just something that was said to you earlier, okay? So with your patience, all right, I believe the state council earlier referred to some representation of the parties, and I just want to remind you of two things. Remember that opening statements are not evidence, and that what the attorneys say is not evidence. And with that, Ms. Love, you can continue, okay?
Thank you.
All right.
And thank you, ladies and gentlemen of the jury. I'd like to report, I hope you all had a great lunch. You can stay awake with me for just a few moments more. So where we left off, the crimes that the defendants are accused of committing in this case. You're going to have the indictment with you. It's going to go back. A listing of them includes the following: conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, murder, armed robbery, aggravated assault, possession of a firearm during the commission of a felony, possession of a firearm by a convicted felon, possession of a firearm by a first offender probationer, and death by receiving stolen firearms, among other things. This list is not exhaustive. You will have again with you the indictment, and you are to consider as the state commits burden. So breaking it down, the evidence is going to show that the defendants, when we say conspiracy, it's nothing elaborate. It's a legal term, which simply means the evidence is going to show that the defendants had an agreement. It will not be a written contract presented to you. There will not be a letter signed in blood by any of the defendants. But what you will see evidence of is the defendants' actions, their presence, their companionship, their conduct before, during, and after a long list of crimes. And what you will see is that the defendants weren't always convicted of these crimes. Sometimes the state no-prossed or dismissed charges. Sometimes the police never brought formal charges. But what the evidence will show is that the defendants did commit those crimes. And when we're talking about a conspiracy, an agreement, just an agreement, unspoken agreement, we're gonna participate in YSL through a pattern of racketeering activity. That's another large word that is used in the legal community, but regular folks, myself included, just don't generally tend to use it. Racketeering activity is nothing more than certain crimes, the crimes that are listed out in the indictment. You will see that, and the court will instruct you, I expect, that those crimes constitute racketeering activity. And as I stated before you all broke for lunch, a conspiracy requires just one overt act. So you will see evidence of several overt acts. Several acts that were done by these defendants and by unnamed and unindicted people as well, to further the interests, to further the goal of the conspiracy that the defendants participated in. You will see overt acts meant to establish YSL's dominance and control. You will see overt acts meant to gain illegally access to money and wealth and property that did not belong to YSL. You will see overt acts, steps taken on the part of various individuals to act to protect the group as a whole. Steps that have nothing to do with a recording label. Steps that have nothing to do with an A&R executive. You will see steps that were taken solely for the purpose of illegally gaining goods for and on the behalf of YSL and its members. You will see steps taken by each of the defendants to protect the members of YSL, to establish the dominance and control of YSL. Nothing in what I expect the court will tell you, nothing in the evidence will suggest that any of the defendants had to be convicted of all of the overt acts in order for you to see that they actually had an agreement. The acts don't even have to be crimes, but they are. And that is how the state expects you will know that these defendants, they wanted to participate in this enterprise. They wanted to participate in this organization through these illegal acts. They wanted to obtain ill-gotten goods that they did not have a right to have through robbery, through stealing, through drug sales, and the like. So we'll start off by looking at the defendants. 6 of them are at the table, and 6 of them are here for you all to decide, has the state proven its case? Rodelius Ryan. Rodelius Ryan is one of those people whose youth and life was swallowed up in the crater created by YSL in the Cleveland Avenue community. The evidence is going to show that in 2019, Rodelius Ryan was 15 years old. And that in February of 2019, Rodelius Ryan used female acquaintances to lure Jamari Holmes to a particular address here in Fulton County. The female acquaintance lured Jamari Holmes to that address, telling Jamari that he would get sex and weed once they got there. Instead, when they got to the address, the female gets out of the car, and the defendant, Rodelius Ryan, and his accomplice, Damone Blaylock, also a YSL member and associate, they then came out to the car with guns. The evidence will show that Rodelius Ryan and Damone Blaylock then fired those guns into the car, where Jamari Holmes, not even 20 years old, was seated, and hit him in the back of the head with the bullet that took his life. Jamari Holmes is another one of those young lives, the evidence will show, that was swallowed up by the crater that YSL created and left in the middle of the Cleveland Avenue community in Fulton County. 12 hours after shooting and killing 19-year-old Jamari Holmes, the evidence will show that Rodelius Ryan doesn't say, I bet I make the news. Rodelius Ryan posts on his Instagram account, I bet YSL makes the news. The evidence will show that in posting about YSL as it related to his flagrant, overt act of extreme violence, Rodelius Ryan was agreeing to and attempting to participate in YSL through this illegal activity. He was promoting the gang. He was showing their dominance. He was showing their power, and he was showing their control. Rodney Uten was also in the car with Jamari Holmes. That's another young life. He wasn't taken, he survived. But he was forever changed by the acts of YSL, conducting and committing violence on behalf of the entire organization. And in case it hasn't been lost on you, Rodelius Ryan's Instagram handle that he used, Slime Business Ride. Because as the evidence will show, slime is spoken and used to signify doing someone dirt. And Rodelius Ryan is proudly proclaiming his association with YSL as he talks about and as he promotes the gang itself. Rodelius Ryan's accomplice, another YSL member who's not here today, but who is a co-conspirator. What did he post after they killed Jamari Holmes? The evidence will show that Damone Blaylock didn't say friendship over females. He didn't say Blaylock over buddies. He said slime over sluts. Slime over sluts, while posting a YSL gang hand sign with the caption, slime over sluts, a green heart emoji, and a green snake emoji, which I expect the evidence will show are the common identifiers associated with YSL. They're the identifiers that they use to announce and project themselves to the rest of the world. And then, on February the 25th, 2019, Rodelius Ryan made another posting where he's flashing cash money on his Instagram page with the caption, fuck YFN. YFN being a rival criminal street gang. The evidence will show that none of this was a part of what anybody has to do to be a part of a record label. The evidence will show that these acts were done in furtherance of and to promote the goals of the enterprise, the criminal street gang that is Young Slime Life. And what did the paper say? 15-year-old, they called Jamari Holmes a known gang member, but the evidence is going to show that that's not who he was to the people who cared about him most. Jamari Holmes was Jamari Holmes. He was a baby, a child, found shot to death inside a stolen car, police said. Jamari Holmes was just the latest victim of YSL's quest to maintain and retain dominance and control of the Cleveland Avenue community. Again, Rodelius Ryan didn't post, I bet I make the news. He said, I bet YSL makes the news. Marquavius Huey, he's also on trial for you to determine whether the state has met its burden of proving he committed the acts that are listed in this indictment. Marquavius Huey showed his agreement to participate in the activities of YSL through a pattern of racketeering activity. He showed his willingness to commit acts on behalf of the gang through his actions. The stolen handgun he had, that was the property of Jeremy Smith. Because as you will see throughout this trial, stolen handguns will become a reoccurring theme. There's no need for a legitimate organization not comprised of people committing crimes on behalf of the organization to have all these stolen handguns. Everybody has a right to have a gun, so if you're legitimate, just go get one. But the evidence will show that in this case, YSL members, stolen handguns every time you turn around. And not just stolen handguns. The evidence will show that most recently in May of 2022, where some of these defendants were found at the home of Jeffery Williams, their leader, it wasn't just stolen handguns that YSL dealt with. It was machine guns. You'll hear evidence that at the home of Jeffery Williams, in addition to the pharmacy full of drugs, that there is a gun with a switch that allows, with one trigger pull, 10 times more bullets to come out at a time than if you just had a regular gun. There will be no evidence to show any need for that in legitimate, ordinary, record deal making business. The evidence will show that the existence of those dangerous weapons like the machine gun, the stolen firearms, those things are all evidence of these defendants' conspiracy. Those things are all evidence of the existence of the enterprise known as YSL, whose goal it is to maintain and retain dominance, control, and ill-gotten gains. Marquavius Huey, on April the 26th of 2019, further showed his actions showed his agreement to participate in YSL through a pattern of racketeering activity, illegal activity. When he took the property, jewelry, money, and a debit card of Dewan Maynard by use of a firearm. Dewan Maynard, another life affected by this crater created by YSL in the middle of the Cleveland Avenue community. Marquavius Huey showed his agreement to participate in this enterprise when he struck Maynard in the face with that gun that he used to take Mr. Maynard's belongings. Marquavius Huey hijacked on October 1st of 2020 a Buick LaCrosse from yet another victim of YSL's violence, Gary Holloman, by force in violation of the law. Mr. Holloman has since passed away, not from that incident. So he won't be here to tell you what he was feeling and how he was able to tell the police who it was that committed this armed robbery. What you will hear evidence of is the extraction from Marquavius Huey's phone where he's planning the armed robbery, where he set up with Mr. Holloman a ruse so that he could have the opportunity, along with another uncharged, unfound individual, so he could have the opportunity to put a gun in Mr. Holloman's face and rob him. What Marquavius Huey did was kind of slimy, the evidence will show. He told Mr. Holloman, hey, your nephew in the Fulton County Jail, Tinquarius Mender, he needs some money on his books. So he wants me to meet with you to get money to put on his books. So Mr. Holloman, because he loves his nephew, and any friend of his nephew coming to him that way is legit, right? The evidence will show that Mr. Holloman arrives intending to meet the person so that he could give to them the money for his nephew. And to his shock and horror, he's met with the butt of a gun. Two people, one with a long gun, one with a handgun, demanding his money. And that day, as the evidence will show, Mr. Holloman wasn't the only person affected by the violence perpetuated every day by YSL. Delmisha Coppage, she just happened to be on scene. She just happened to be right there conversing with and talking to Mr. Holloman when the defendant and his accomplice came up, held him at gunpoint, and demanded their belongings. You'll hear how they directed Delmisha Coppage to just sit on the ground, just give me your stuff. You'll hear how they robbed Delmisha Coppage at gunpoint. The evidence is going to show Mr. Huey's tight relationship with their leader, Jeffery Williams. The evidence will show that Mr. Huey, on various occasions, checked in with, reached out to Mr. Williams to see, hey, I got this stolen item. You want first dibs on it? Marquavius Huey's actions that betrayed his agreement to participate in the conspiracy didn't stop with Gary Holloman and Delmisha Coppage. The evidence will show that in November of 2020, he made terroristic threats towards Justice Woodard after Woodard told Mr. Huey she'd see him in court. He said, you will die if you put the police on me. Showing their association, showing their agreement, showing their intention to participate in this organization, this enterprise through a pattern of racketeering activity. The evidence will show that while fellow associate Tinquarius Mender was an inmate at the Fulton County Jail, Mr. Mender, Mr. Huey, and Mr. Williams conducted a recorded video call wherein Mender relays he needed something and Williams pointed to Mr. Huey to take care of it. And then flashed Mender the YSL sign. You see, it's not a crime to flash a YSL sign. The evidence is going to show it's not a crime to participate in a video call. The evidence is going to show that it is not a crime to endeavor to provide something for a friend who's locked up in jail. All of that is okay. These acts aren't listed on the indictment because they're crimes. They're listed because they are actions. Actions that the legal leads for is overt acts that reflect each of these defendants' tacit or unspoken agreement to participate in this enterprise through a pattern of racketeering activity, to be a part of this group, to gain ill-gotten goods through crimes listed in this indictment. I don't even have to use the word racketeering. I don't even have to use the word conspiracy. They endeavored to do some illegal stuff to get a bunch of stuff that didn't belong to them. And somebody, more than one, but all we need is one, the evidence will show that at least one person took a step towards furthering that goal. So when you get the indictment, after however long it takes us to get there, and you're looking at 191 acts and thinking, state, really?
Argument, objection.
I sustain the objection.
Thank you, Judge, I'm moving on.
Move on. That's argument.
The evidence is gonna show that these steps that they took are akin to you just going out to get some toilet paper to further a conspiracy to go TP a house. Doesn't have to be a crime, it's just an act, an action. The evidence is going to show that the defendant Jeffery Williams' words and actions also betray his participation in the conspiracy. I expect that you will hear from a YSL associate and member at trial that the defendant Jeffery Williams rented a car, notwithstanding that Jeffery Williams had his own cars, but he rented a car which happened to be a silver Infiniti sedan that other YSL members, among them Demonte Kendrick and Shannon Stillwell, used when they openly and notoriously gunned down Donovan Thomas on January the 10th of 2015. The evidence will show that after that horrific act, I expect yet another YSL associate will come in here and tell you that Jeffery Williams paid them money, gave them money to go to Miami and lay low in the wake of the Donovan Thomas murder. Later that month, on January the 26th of 2015, Demikion Garlington, who isn't before you for your consideration today, but who is in fact a YSL associate and co-conspirator of these defendants, he posted a video of the defendant Jeffery Williams looking into the camera and saying these words. So, I think lie to their mama, lie to their kids, lie to their brothers and sisters, and then get right into the courtroom and tell the God's honest truth. Don't get it. Y'all need to get fucking killed, bro. That's from me and YSL. The defendant's words tell you that there is an enterprise. The defendant's words establish his willingness and agreement to participate in this enterprise through illegal activities.
Hi, good afternoon. We are coming to you live as we continue our coverage of the memorial ceremonies for former First Lady Rosalynn Carter.
Right now, the Carter family motorcade just arrived at the Jimmy Carter Presidential Library in Atlanta, and that's where Mrs. Carter will lie in
What the heck is going on here? Hold on.
You see the honor guard right there. Now, tonight, the public is invited to pay their
going on?
respects to the former First Lady, and we will be covering all of these events for you in the several days that we will be honoring the life of Mrs. Carter.
And you know, this morning we saw a lot of...
They're investigating.
There we go. Hold on. Wow. This is crazy. I have no idea what's going on, you guys. Hold on. There we go.
Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack. Thank you so much, ladies and gentlemen, for being patient. Thank you so much for being honest during this very lengthy process that preceded this point here today during the voir dire process. I appreciate you all being here, exercising your civic duty, and honoring your obligation to pay close attention to what's going on in this courtroom for the next several, however many weeks. Some people like to say that opening statements are a roadmap to what the trial will show. Instead, I'm going to give you an overview, a bird's eye view, because you're going to be sitting here with evidence for the next several weeks at least. And you will be able to see what that evidence is. Nothing that I say to you during this part of the trial, and nothing any other attorney says to you during this part of the trial is evidence. But I can tell you what I expect the evidence to show. And what I expect the evidence to show in this case is that YSL, the group made up of the defendants sitting before you today, along with other both indicted and unindicted co-conspirators, YSL operated as a pack. The quote that I read to you earlier is from one of my favorite books as a kid, The Jungle Book. In case anybody recognizes it, those were right out Kipling's words and not mine. But they are appropriate for where we are today. For 10 years and counting, the group calling itself Young Slimelife dominated the Cleveland Avenue community of Fulton County. They created a crater in the middle of Fulton County's Cleveland Avenue community that sucked in the youth, the innocence, and even the lives of some of its youngest members. Now, the evidence is going to show that this group started out as a group called Rock Crew. And Rock Crew stands for Raised on Cleveland. The evidence is going to show you that Rock Crew, in fact, is a criminal street gang. It's not the kind y'all are used to. If you're more familiar with the national gangs, such as the Bloods and the Crips that operate in LA or in Chicago. But make no mistake about it, Rock Crew is and was a gang. It consisted of 3 or more members with common identifiers, signs, colors, linguistic choices that committed crimes on behalf of and in furtherance of Rock Crew itself. That particular organization aligned itself under an umbrella of a larger, more traditional street gang called Sex, Money, Murder, Bloods. They adopted the nomenclature. They would do things like replace C's in words with the letter B, because traditionally Crips and Bloods were not aligned with one another. So Cleveland Avenue became Cleveland. Some of you may have indicated during voir dire you've heard or are familiar with the Cleveland Avenue area. Maybe you've even heard of Cleveland Avenue Day. The evidence will show that this is where that comes from. The evidence will also show that sometime in 2012 or thereabouts, an internal rift or divide occurred among the members of Rock Crew. Now, the defendant, Jeffery Williams, seated back there yawning right now, he was an original member of Rock Crew. And the kind of crimes that Rock Crew did consisted of smash and grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffery Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffery Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You will hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checks all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. and last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object to that statement, please, as burden shifting.
Object basis?
Burden shifting. And under Parker versus the state at 277.
Why don't we take that up and
39.
I'll note your objection. I'm sustaining the objection. Why don't you rephrase, madam?
yes, Your Honor.
Just rephrase it. Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove or certain innocence, they're presumed innocent. And it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time, okay? All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read or spoke to you earlier goes as follows. Because of his age and his cunning, because of his right.
This is argument. This is not
What's your objection, Mr. Harvey?
that it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, Your Honor.
All right.
The evidence will show that these defendants, that the members and associates of YSL, they knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew and they knew that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King Slime, as they call him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffery Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood Family. You will hear experts come in here and tell you more about how the Inglewood family bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies. 2015. Gunned down. Openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance, and to establish control, and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift Young's Limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state will be proving to you over the next several weeks include conspiracy to violate the Racketeer Influence and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say Rico. There's no substantive allegation of Rico violations here. And by that I mean there's a difference. Here the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if 2 people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and went and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go and do this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those two people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they are agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held long-born guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Fomarius Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stillwell, Diamante Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor.
You have an objection?
Yes, sir.
Basis.
Those motion.
All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters at your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right?
What are they doing now?
Here's what we're talking about today on Daily Blast Live.
It's Cyber Monday, but
For
has the
real?
hype over holiday sales changed since the wild Black Friday showdowns in stores? Then John Schneider will be here.
Just a minute, guys. I'm trying to figure out what's going on. Hold on. Right here. This is crazy.
Of each other. Dexter Montgomery, minding his business, happened to drive in just a little too closely behind another YSL associate, who then phoned up the gang who was posted up at the trap house. And in minutes, two more YSL associates showed up with a long gun and handguns. Dexter Montgomery had no idea he was about to lose half of his head that day. As Dexter Montgomery left the gas station, two YSL associates followed behind him. And as he stopped at a red light, they opened fire. Miraculously, the evidence will show that Dexter Montgomery survived, but literally half of his head is gone. You'll hear from and see Dexter Montgomery during the course of this trial. The evidence will show that after that happened, law enforcement, at first it wasn't the gang unit, but the gang unit recognized some of the players, Walter Murphy, other members of YSL. And so they began to assist in the investigation. And they learned the YSL gang members said, we got a call that one of us needed some help. He didn't know who this was pulling up behind him, so we just responded. You'll hear that investigators, Gaither and Dennis, said, well, wait a minute, did you know what you were responding to? They're like, no, we don't have to know. If our boy needs help, we're gonna respond. They said, well, where'd you get the gun? Oh, they're by the door of the trap house that we were in. They're just there, ready for us to use when we need to. Their words, I can't make it up. The evidence will show that actions of YSL gang members and associates on behalf of their leader when they felt someone disrespected Jeffery Williams or any other member of their pack, they made threats. Not quiet, whispered threats, loud, public threats with wide, vivid displays of firearms. We're not going back and forth. There's got to be some Biggie and Tupac shit and shooting up Wayne Carter's tour bus. The evidence will show that all of those actions, they're not elements of the offenses that are charged in the indictment. We don't have to show those things in order for you to find them guilty, but the evidence will show that those things prove the existence of the conspiracy, of the agreement itself. The agreement on the part of these defendants and other charged and uncharged co-conspirators to be a part of this organization known as Young Slime Life through a pattern of this illegal activity outlined in the indictment. There are numerous victims that you're going to hear about. Shannon Stillwell is another defendant who is before you, being accused of various crimes in this indictment. Shannon Stillwell is alleged by one of his own crew, by another YSL, two other YSL members, to have been one of the gunmen who took the life of Donovan Thomas. The evidence will show that Shannon Stillwell was arrested. He was arrested after some investigation by the Atlanta Police Department. The evidence will show that the information initially relied on by that first arresting officer, it didn't pan out to be actually accurate. So when the case got to the district attorney's office, more investigation was conducted. The evidence will show that the office didn't just take the word of the person who originally identified certain people as having committed a murder of Donovan Thomas. Instead, as the evidence will show, what our office did was dig. dig to find out whether the people who were talking were actually in a position and a place to know the stuff that they talked about. And what they learned was that that person originally relied on Investigator Thorpe. That person was just lying. And so the people that Investigator Thorpe originally arrested on the Donovan Thomas murder, they were released at various times on bond as the office continued to investigate further. The evidence will show that our office did not just stop at the word of one YSL member. The evidence will show that yet another accomplice corroborated the words of the first YSL member that talked. The evidence will show that cell phone records further corroborated the information law enforcement was getting from these people. And ultimately, Shannon Stillwell, Demonte Kendrick, Justin Cobb, Javoris Bradford, they were all indicted in this particular instrument that you'll have for your consideration. But the only two people who are in front of you for you now to determine whether or not state has met his burden are Demonte Kendrick and Shannon Stillwell as it relates to Donovan Thomas's murder. However, between the time that this indictment came down and the time that our office decided, no, we need to look into this investigation some more, Shannon Stillwell was released from jail. But he had to wear an ankle monitor as a condition of his bond. The evidence will show that during the time in 2015, after a lot of arrests were made following the murder of Donovan Thomas, that the violence in Fulton County, the gun violence that had continued over the course of that year, it kind of subsided a little bit.
Basis. I sustain the objection.
Yes, Your Honor. The evidence will show that around 2019, 2020, law enforcement investigators, they started noticing some activity on the part of gang members. They started paying particular attention. One of those investigators was Investigator Marissa Vitorito. You'll see and hear from Investigator Vitorito, and you'll learn that one of her jobs as a law enforcement officer, one of her background experiences was that she was a probation officer, so she had a lot of information about a lot of YSL gang members. You'll hear that initially, after Shamel Drinks was gunned down, Detective Hogan with the Atlanta Police Department, he didn't have any leads. As a matter of fact, he came back to the precinct lamenting the fact that he had no leads on this homicide that just occurred at Windsor and the I-20 entrance ramp. Young man killed, gunned down inside his car. When Investigator Vitorito began talking to Detective Hogan, she saw that Detective Hogan did have some footage from the gas station right up from that location. And that Investigator Hogan was looking to find the people in the gas station because that gas station was the last place that Shamel Drinks was seen alive. One of the people in the surveillance footage was wearing a very distinct hoodie and coat. And as it would happen, Investigator Vitorito had hours earlier been at a Waters Road location, one of YSL's hangouts. As the evidence will show, a place from which they conducted transactions. And that the Waters Road address had been shot up, and investigator Rico happened upon Shannon Stillwell and other members of YSL in the same outfit he was seen in the surveillance video on at the time Shamel Drinks was inside the gas station. The evidence will show that further investigation revealed that Shannon Stillwell was wearing an ankle monitor at the time that Shamel Drinks was gunned down. And that ankle monitor put him right there at the place that Shamel Drinks took his last breath. The evidence will show that in this murder, much like in the Donovan Thomas murder, there was a rental car involved. A rental car which these defendants had gone and gotten the windows blacked out, tinted on earlier the day that Shamel Drinks was gunned down. Tinted the windows of a rental car. The evidence will show that it was to evade being seen by the opposition. The evidence will show that as a result of all of this violence and activity, during the midst of it all, investigator Vigorito had secured a wiretap for Demikion Darlington, YSL gang member and associate. She was able to listen and detect hours of the goings on of the enterprise. She learned throughout the course of her own investigation and during her time looking into YSL that a rival gang member, Rayshawn Bennett, ended up at the Fulton County Jail at the same time YSL gang member Jaden Meyer was there. The evidence will show that Jaden Meyer, upon seeing Lucci, reaches out to get permission from King Slime to take Lucci out. The evidence will show that Jaden Meyer actually endeavored to stab Rayshawn Bennett to death, but that he was unsuccessful. The evidence will further show that Jaden Meyer wasn't the only one reaching out to this defendant, Jeffery Williams, for permission to commit a homicide. Looking at Shannon Stillwell's words along with his actions, happening upon the lyrics while trying to solve the murder, the evidence will show that law enforcement found one nugget spoken by Shannon Stillwell. I just beat a murder rap, paid my lawyer $30 for that, after he was released on bond for the murder of Donovan Thomas, and before he actually took the life of Shamel Drinks. The evidence will show that the young man on the left is Shamel Drinks in life. And that the photograph on the right is what was left of Shamel Drinks after YSL and the crater it created in the middle of the Cleveland Avenue community took that life from his family, friends, and loved ones. I said a lot, and I'm not the only one you get to hear from today. So you might be happy, I'm about to sit down. I want to ask you to make use of those notepads and those pencils that you have in your possession. The court's already given you the instruction, take notes. Rely on your memory. Use the notes to document and help you remember after you've heard weeks and weeks and weeks and scores of witnesses, who said what. I expect that as you listen to and evaluate witnesses who come in to testify, there will be witnesses who you discover changed their stories from the time they first made a statement to the time they actually had to appear here in court, in public, and tell them folks. I expect that the evidence will show that there are some witnesses you will assess are just scared. Some are embarrassed, some are intimidated, some don't want to remember, some just plain don't remember. The court alone gives you the law on how to deal with and how to assess those witnesses. I only ask that you follow closely the instructions that the court gives you. Look at who the witnesses are. Look at who they look at while they're on the stand. They don't look at or won't look at while on the stand. Look at how they answer questions posed to them from the state versus questions posed to them from the defense. And if the occasion arises that you find that a witness as presented in court says something different than what they said previously, you determine why it is you believe that they said something different once they got in court. Words and actions. The defendant's actions coupled with their words. They prove the existence of the enterprise. Their actions and their words, the evidence will show, proves their agreement to participate in this enterprise through these illegal activities outlined in the indictment. Preserving, protecting, enhancing the reputation, power, and territory of the enterprise through acts including murder, assault, and threats of violence are what the evidence will show these defendants did over the last 10 years. The evidence will show that the violence didn't stop in 2015. Preserving, protecting, and enhancing the reputation, power, territory of the enterprise by the posting of messages, images, videos, and songs demonstrating their allegiance to the enterprise and willingness to engage in violence on its behalf are what you'll see evidence of over the course of the next several weeks. Maintaining armed individuals ready and willing to preserve, protect, and enhance the reputation, power, and territory of the enterprise through the use of violence. It's what the witnesses and the evidence you will see. Obtaining money and other property through illegal activities like robbery, theft, and illegal drug sales and distribution. And obstructing law enforcement, killing 12 shit. Investigations and court proceedings through witness intimidation and attacks upon law enforcement officers. You'll see it for yourself. The children whose innocence this organization claimed as its own. And in the end, the evidence is going to show you that YSL is a Rico enterprise, nothing fancy about it. The evidence is going to show you that it's also a criminal street gang. Those two are not mutually exclusive. That these defendants participated in this enterprise in a way that had nothing at all to do with the record label, except maybe their actions as reflected in their songs made their music more real and perhaps more appealing to somebody. The evidence will show that the defendants, they talk about YSL while they talk about the crimes they committed. And while they talk about the crimes they're going to commit, you'll see that this evidence proves that YSL is a criminal organization. The defendants have been associating together for many years, committing crimes together against the general public, against rival gang members, as the evidence will show, against law enforcement, and against each other. The evidence will show they agreed, they willingly participated in these activities. In the end, the court has told you and will tell you again that you are to evaluate the evidence and apply that the law the court gives to you to that evidence and render a verdict that speaks the truth. I expect that at the close of this evidence, you'll see that the defendant's presence, companionship, and conduct during all of these illegal activities, their words and their actions not only show the existence of the criminal enterprise called YSL, it also shows the conspiracy. And in the end, we're gonna all come back and make our arguments to you. But the one thing that I'm gonna be doing, our team will be doing, is asking you to uphold your duty and render a verdict, the only verdict that speaks the truth, and find these defendants guilty of each and every crime listed on this indictment alleged against them. Thank you.
Finally. Oh my God.
Ladies and gentlemen, we've been going a minute. You want to take a comfort break? Anyone? All it takes is one, okay, all right. Two, see, and then everybody else will go after that. Let's take 10 minutes, and then whoever next would like to make an opening statement, I'll offer that to them at that point, okay? All right, so we'll be in recess for 10 minutes. Remember my admonitions to you. All right, we're in recess.
I'm sorry, my face. Okay. That lady, all right. Oh my God, what was I going to say? I lost all focus, okay? She almost could have got a mistrial here. Now, defense for Young Thug, he's good. He's going to be entertaining. And he's got a co-conspirator also. So that means there's two defense. Or I could be wrong. What am I cooking? Oh my God. Okay, because I didn't have a Thanksgiving dinner. So I'm cooking ham, green bean casserole, mashed potatoes, green bean casserole, pumpkin bars. And sorry, I didn't know I was unmuted when I was putting everything in garbage bags. Yeah, but I'm saying, yeah, you're right. At this hearing, they're not all there. So it sounds like they took the whole gang down, huh? Did you? I want to make what you're making in the crock pot. I need your recipe. I'm sorry if it sounds like I'm yelling. Oh my God, my head. La, 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 la. Hold on. I don't know what to do about this headache. He wasn't? I think I talked to you all that day, didn't I, Grandma? That's right. I was live and you were here with me. That's right. And didn't we do Jimmy Hoffa that day? Oh my God. She argued with the judge. You didn't see that part. She lost my attention. Yeah, that's what I thought. Oh, my poor head. Woo. Thursday he was wiped out. We just had sandwiches. There you go. Okay, let me look at this. I cooked potatoes and ham, onion, celery together, and a little bit of water and milk. Is that in your crock pot? Oh my God, yummy. I got to screenshot this. All in the crock pot, right? Oh, garlic. I put garlic in almost everything. A small one? Okay. I went to the doctor's today, you guys. That was my excitement. Okay, do you want to put a bone stimulator in my spinal cord? By my spinal cord, whatever. And I told them today I don't want to do it. So I'm going to start PT again. My surgery didn't work, you guys. Yeah. Sucks ass. Yes, I told her, they give me the option. We talked about my options, right? Because I know I'm going to have this chronic pain the rest of my life, which I can handle it, okay? But this type, no. What's going on right now? And when I went to PT before, it helped that nerve, so my hand wasn't going numb no more. I'm too afraid to have them open me up again. I am. I don't want to see the surgeon. No. They sent me a bill for over 100 grand. Good luck, you're not getting it. Oh, thank you. I made it at the last minute. My appointment was at 8 a.m. No, that's scary. Don't you think that's scary? Well, I guess I'm just smart nowadays. I know how to stick up for me, and all these doctors ain't right. You know what I mean? Because it's a foreign object in my body, and anytime I've had a foreign object in my body rejected it, and I had complications. Because I had a pain pump put in. That was horrid. The fluid was leaking out of my back. Got infected. I had, what are those things called? Oh, God. I can't remember everything. I know. That's my only fear. Well, it didn't help me having that stroke. Because I got some paralysis on my face. If you really look at me, you can see it. Yeah. It is what it is. Yeah. You know what anesthesia did? And I didn't know it. It caused that a year later. My hair fell out. Half my hair. And I take really good care of my hair. Yep. You do understand that? Okay. What? What's up, Grandma? I mean, baby. What's up, baby? And thank you, you two, for being here. I appreciate it. Don't forget to hit the like. Oh my God, it's such a dork. You guys kind of cheer me up, though. You two. And so does Karen and Miss Barbara and Jimmy. Hey, Grandma, what happened to our girl, Far Q? What happened to her? Is she okay? Yes, it did. Yep. It was crazy. I am. My dad found me. I remember, oh my God, I remember, woo, when I passed out, I tried to save myself. I tried to open my door I was on the ground with my foot. And I know I laid there for 2 hours because of my alarm. So he pretty much saved me. Yeah. I know, right? I mean, you and her got pretty close, you and FarQ. And with Miss Barbara. And then I liked her too. And then all of a sudden, poof, gone. I hope she's okay. If you guys end up seeing her, tell her we miss her. She was funny, wasn't she? Interesting. Hold on, I gotta check my potatoes. Oh. Oh, come on. What the hell's going on around here? All right. Okay, I'm back. Okay, let me read the comments here. Okay, thank you. I guess this is another case where I care more about them. Okay, you know what? This is what happens. You end up creating like a friendship, a bond. Like I have one with you. I do with baby too. Miss Barbara. And I don't know. It sucks. Even Miss Barbara asked. Yeah, she sure did. They were thinking that it was because somebody was disrespectful on my panel. Why wouldn't she come in and say hi? Right. She changed her name? What the hell? Well, that means she's around, Grandma. Yeah. Maybe. I don't go to many channels. You know what I mean? Oh. Okay. Maybe she's sick, jailed, kick off of YouTube. For what? Oh. Oh my gosh. Wow. Well, maybe I can find her. Even though she changed her name, I'm going to look at my friends list and I'm going to, because I set it up to you guys, okay? It doesn't matter if you make content or not. You know what? Maybe I should do a SOS or something and say, where are you? Right. Oh, I've almost been kicked out for saying jerk. Really? Boy, they're getting really weird. But you see all these bigger channels, they can write really gross terms. I don't want to say them in their titles, and nothing happens to them because they have millions of followers. Hey, you guys, sub up to my conversation with the killer. I need more peoples. I need more hours. I figured I'd have them by now. Because I want to share my relationship with high profile cases, which I'm not going to tell everybody. I want to surprise everybody. They'll be shocked. You couldn't find her? Well, I don't either. I know, but I need people. Okay, because this is what I'm going to do. This channel is not monetized by choice because these are the victims and the families, and I cannot make money off that. No. However, I want to monetize that channel because it has to do with me and the convicted, right? So I treat them like a human, right? Some have been long term, others no, a few times, but I swear to God, you guys will trip. I'm even in shock myself. That's because I'm nice. And yes, I reached out, but the thing about it is, you know what I say?
Got no court reporter.
Issue.
I got no court reporter.
I understand.
All right.
Your Honor, if it's all the same to you, it doesn't need to be on the record for mine.
It does.
Okay.
Okay.
It needs to be on the record for me.
All right. Sergeant, do we have everybody back present, sir? Can I get all our attorneys to please kind of start making way toward your seats, please? Yes, sir. Thank you, sir. All right. Can we check on our jurors? Are they all ready, sir?
Yes, sir. Yeah.
Okay, all right. Mr. App, what do you need?
Your Honor, my understanding, I planned my opening arguments around I'm not using any PowerPoints. I didn't turn any over the state because I planned my opening arguments around using just paper and notes to speak to the jury off of, with the understanding that I was going to have a lectern to speak, to put those papers on in front of the jury. And my understanding was from Mr. Steele that there was a conversation with Captain Kendall last week that a lectern, which is in the hallway, would be allowed to be placed up there so that then those papers could be used. I understand now there's some disagreement or understanding about whether a lectern that's out there can be used or not.
I wasn't involved in that particular conversation, but I want to say that also, in order for us to for you to be heard, my suggestion is you probably use the podium. And there's plenty of room on the podium, that particular podium that's immovable. And it's also got a microphone. And you're welcome to walk back and forth, sir. You can walk around the well. I'll give you permission to do so. You won't bother me.
So I can tilt this.
There's
a sign on
do
it.
not move.
Tilt.
Do not move. Do not. Yeah, because it's it's part of our evidence presentation system.
Well, and there is a lectern on wheels that's 20 feet away from here that if we could just move it into the.
Well, you've also got the challenge of you got some jurors there available. So jurors that are sitting there closer. So I prefer you not do that. Okay. You have to do the best you can with the table you have. Like I said, you can walk around. You can even put some of your stuff on the edge of the state's table if you'd like to. And also related to that, if there's anybody in the media that is zooming in on any of the things that's involved on any council table, please do not do that. Okay? If you are, don't do it. So just please, just wanted to make you all aware of that. All right. So, Mr. App, if you'd like to, since all this furniture belongs to me, technically, you are free to put your whatever you need on the edge of the state's table.
Can I use the witness stand when I'm giving my?
Yeah, sure. Absolutely. Absolutely.
I prefer the lectern, but I'm just.
Yes, Mr. Sharp.
As the person who spent most of this morning trying to procure a lectern, there's also.
You didn't tell me though, and we could have gone through this earlier.
I spoke to Captain Kendall last week. I spoke to numerous members of the sheriff's department this morning, and I was going through every procedure that I was supposed to go through.
Well, ultimately, it's my decision, right?
I understand.
Okay.
There is a much smaller lectern that can easily be picked up and placed here in courtroom 1D. It would literally take 2 minutes.
Sir, I want to move the presentation of this evidence. We could have discussed this weeks ago, and we could have gone ahead and planned it. I could have brought it over here and test drove it, but you didn't give me that opportunity, so let's move on.
Okay.
Thank you. Anybody else?
Do you know what time?
No,
6 o'clock.
I don't know what time we're going to, but I'll let you know as soon as I'll figure that out in just a little bit, Mr. Steele. Okay. All right. Who's making the opening statement next? If so.
Definitely me, though.
Okay. All right. Let me know when you're ready, sir.
We're just going to set up on Zoom.
Okay. All right. Let me know when you're ready.
Your Honor.
Yes, Miss Act.
I'm good. I'll see you.
Kokomo is helping with this.
That's fine. That's fine.
Thank you.
That'll work out. And Ms. Weaver will yield some space to you, so, okay.
Being most accommodating.
There you go. We aim to please.
Oh, man.
I sent them to you. I think. Yeah, I think I emailed the first two to you, but I don't. The second two, Chris, Miss Love's gonna have to send them to you because they're password protected. So if you ask her to send those to you, she can. I went ahead and, yeah. I think he said he's ready.
Oh, you ready?
Okay, all right. Can we summon our juror, Sergeant Ingram, please? All right. Please be seated. All right, thank you, Sergeant Ingram. All right, does any member of the defense wish to make an opening statement this time?
I would, Your Honor, on behalf of Mr. Stillwell.
All right, Mr. Sharp, you may proceed, sir.
Thank you, Your Honor. May it please the court. Good afternoon. My name is Max Sharp, and along with my co-counsel, the gentleman with the white hair back there, his name is David Botts. And together we have the honor and privilege of representing Shannon Stillwell. Shannon Stillwell is an innocent man. He's been accused of a murder of Donovan Thomas in 2015. He is not guilty. He's been accused of a murder of Jamal Drinks in 2022. He is not guilty. He has been accused of conspiring to violate the Georgia State Rico law. He is not guilty. Now, I am going to deliver an opening statement that will preview what I believe and what I believe the evidence will show in this case, and the evidence that will come in trial. But before I even start previewing what I believe the evidence will be, I want to discuss with you some preliminary matters regarding this case. The first preliminary matter that I wish to discuss is my client's name. Okay? On the indictment, you will see, when you look at the indictment, that my client is listed as Shannon Stillwell, also known as Shannon Jackson. Okay, and there's a simple explanation for that. You will learn that his mother was a Stillwell, but he was raised by his paternal grandmother, Betty Jackson. So at times he's been a Stillwell, at times he's been a Jackson. He's indicted as Shannon Stillwell. I know him as Shannon Stillwell, but throughout this trial, some people may say Shannon Jackson, some people may say Shannon Stillwell. I may slip up and say Shannon Jackson. But we're talking about the same person, Shannon Stillwell. Second preliminary matter. It has not been lost on me that my client, it's not lost on any of us, that my client is charged with 2 murders in this case. He's charged in 2015, and the evidence will show that he was wrongfully accused. And that case never went to court. He was accused in 2022, wrongfully, based largely on assumptions made about the 2015 case. We plead absolutely not guilty. With our backs straight and our eyes wide open, we plead not guilty to those charges. And finally, ladies and gentlemen, as far as preliminary matters, as you probably have realized through jury selection and the fact that we have some visitors from the press here today and different things about this case, this is somewhat of a unique case. It's drawn some attention. But the thing I want to stress is that this case is no different than any other case in the state of Georgia or the United States of America as far as criminal cases go. And it has the same ground rules as any other case tried in this great union. The ground rules of this case are that the defendant, Shannon Stillwell, and all the other defendants are presumed innocent. The state bears the burden of proving their case against all the accused individually. And the state's burden of proof is the highest burden in our system, beyond a reasonable doubt. Beyond a reasonable doubt. Okay, ladies and gentlemen, the state started talking in their opening about about colors and hand signs and different markers and gang activity and all the rest. And I anticipate that the state will attempt to bring in colors and their belief about what colors mean in this case. Throughout this case, I'm going to ask you to focus on a couple colors as well, just to keep in mind as you hear the evidence. Okay, the first color is dollar bill green. Dollar bill green, as you may guess, is the exact shade of green that the U.S. government uses when printing U.S. currency. And the evidence in this case will show that many of these young men grew up without dollar bill green. The evidence will show, and you'll learn about different areas of Atlanta, Capitol Homes, Jonesboro South, places that have since been revitalized in some ways, but back 15 years ago were not nice places. Despair, lack of opportunity, poverty, lack of positive role models. You'll hear about Shannon and his upbringing. You'll hear that he grew up in the Forest Cove Apartments, which has since been condemned. And he was raised by his paternal grandmother, Betty Jackson. He couldn't live with his mother who had succumbed to drug addiction, and it was his paternal grandmother, Betty Jackson, who raised him. And she raised him in the Forest Cove Apartments, and you'll hear that she loved him. Poured love into him, called him her sweet thing, and he called her mom because she was mom. You'll hear that despite the love and guidance that Miss Jackson tried to pour into Mr. Stillwell, at the age of 14, without other people providing him guidance, he dropped out of school. And he decided that he wanted to be a rapper. You'll learn about the rap industry in this case. Then you'll learn, you probably already know this, but becoming a rapper is not the same as signing up for a job at Home Depot, where you work for 2 weeks and you get your first paycheck. When you're chasing superstardom in the rap game, those paychecks might not come for a long time. And sadly, they may not come at all. It might be a dead end to nowhere. You'll learn about the vast numbers of young men with the same dream as Shannon and how the supply of potential rappers greatly exceeds the demand for superstar rappers. That was really a bad occupation to try to get into when it really comes down to it. But Shannon was 14. And you'll hear how he tried to hone his skills and try to make it in the rap game. But you'll hear that Shannon, like many other young men chasing the same dream, weren't making any money. And bills have to be paid. And kids have to eat. And rent becomes due. In this case, and we're not going to hide from it, the chase of dollar bill green turned into a different shade of green for Shannon and many others. That type of green, that shade of green is called bud green, which is actually a color. You can paint your house bud green. But in this case, of course, bud green stands for marijuana. And you'll hear how Shannon, trying to make it in rap, sold marijuana. The state has alleged in their overt acts, okay? These are acts that they claim prove that there's some Rico conspiracy afoot. You'll hear that on August 23rd, 2013, Shannon was charged with possession of marijuana with intent to distribute approximately 1 ounce over 10 years ago. And you'll hear that he pled guilty and did his time. You'll hear that in 2015, in July of 2015, he was charged with possession of marijuana with intent and possession of a firearm. And you'll hear he pled guilty, took responsibility, did his time. You'll hear that in September 25th of 2019, he was arrested and charged with possession of a firearm. And he took responsibility and he did his time. We're not hiding from the fact that Shannon Stillwell has sold drugs. We're not hiding from the fact that he's been found in possession of marijuana. We're not hiding from the fact that he's been found in possession of a firearm, which is always synonymous with selling drugs. These are his path, his past, his truth, and they were his decisions. His motivation was to make money for him, to live, to pay rent, to eat. Ladies and gentlemen, we're not hiding from the past, but the evidence will show that Shannon's decisions, starting over 10 years ago, had nothing to do with YSL or any other organization. You won't hear evidence that Shannon was selling marijuana and then calling someone from YSL saying, hey, I got some money to support the organization, or calling Jeffery Williams and saying, hey, I got some money for you, man. No, it was for him. He was a drug dealer. He pled guilty. He did his time. Just like thousands of other people in Atlanta. This has nothing to do with YSL. Has nothing to do with the January 10th shooting of Donovan Thomas. It has nothing to do with the 2022 shooting of Jamal Drakes. On count 1, on this indictment, the state charges Shannon Stillwell with conspiracy to violate the Rico Act. They say on or between January 24, 2013 and the 8th day of May 2022, he and others unlawfully conspired to acquire, maintain directly and indirectly an interest in and control of United States currency and other personal property through a pattern of racketeering. The state in their opening said, further the interests of YSL, further their goals. They also said they endeavored to do a lot of stuff to get them a lot of stuff. Okay, it's a little bit more complicated. And Rico, the actions need to be part of a racketeering organization, not a drug dealer selling drugs to put food on his own table to afford studio time to chase his dream as a rapper. I'm going to ask you, as close of evidence, to find Shannon Stillwell not guilty, count one. Okay. The other color, besides dollar bill green and I guess Bill Bud green, that I'd like to talk about is Fulton County blue. Now, Fulton County blue refers to the Fulton County Jail, 901 Rice Street, where people are taken when they're arrested for felony charges in Fulton County. And Fulton County blue refers to the jumpsuits that these individuals wear, the county-issued jumpsuits that are typically navy blue, but deep navy blue, and say Fulton County inmate on the back. You'll hear about the conditions of jail life and Fulton County jail life in particular, and common sense dictates some of this. You're confined to a cell, sometimes with another man sharing that small cell with you. You have no privacy. Use the bathroom in front of men, shower in front of men. You're in fear, danger. You're separated from your family and your loved ones. But most importantly, the men wearing blue, Fulton County blue, they've lost control of their lives. They've lost control of their destiny. Their destiny is now in the hands of the judicial system, in the hands of prosecutors. Ladies and gentlemen, Fulton County blue is going to be a very important color in this case because the state's key witnesses in this case that they're going to call to testify, that I anticipate that they will call to testify against my client Shannon Stillwell, when they became involved in this case, they were all wearing the Fulton County blue. When Mary Zachary, Kenneth Copeland, Sammy Davis, Tremont Stillwell, Spencer Wright, you'll hear them testify if they're called. You'll hear what they've said previously, perhaps. But what you should keep in mind is, when did these men say what they have to say? Did they say it when they first got the information to share? Or what they claim they first got the information to share? Or did they share it when they found themselves wearing the Fulton County blue? When they no longer had control of their destinies and they needed a favor. And they decided to insert themselves into a high-profile case that could solve all their problems. Okay. Let's talk about January 10, 2015. That's the case involving Mr. Thomas. And the evidence will show that this was a high-profile case. And the reason, this is not me talking. I anticipate the evidence will show. I anticipate the state's own witnesses, the state's own gang investigators will tell you, not me talking. I anticipate they will tell you that Donovan Thomas was a big deal, that he was a gangman, that he was a leader of the Inglewood family Bloods in Atlanta, that he was high-ranking. And that's what made this case a big deal on the streets. You'll also hear that this case, the shooting of Donovan Thomas, was caught on surveillance video. Now, I'm not going to suggest that it's the highest quality surveillance video, but it was caught on surveillance video. And you'll be able to watch the surveillance video. And you'll see McDaniel Street in downtown Atlanta at about 7:20 p.m. on January 10, 2015. Remember, winter, it's cold, dark. And you'll see a car zoom down McDaniel Street towards Northside Drive, headed northwest, I believe. And you'll see and you will hear testimony that Mr. Thomas was with other individuals. What they were doing, I don't know, but he was with other individuals in a parking lot in between two barbershops, one being Mr. George's barbershop and one being Mr. Bernard's barbershop. And you will hear that this car zoomed down this dark street on that January 9th, and it appears from the video that you will see that an individual starts shooting out of the sunroof in the direction of Donovan Thomas and others. And you'll see that surveillance video for what it is and what it isn't. And you will also see how quickly everything occurred that night. A matter of seconds. Detective Thorpe is the Atlanta Police Department detective that was assigned this case in January 2015. And you'll hear that he gathered the evidence from the crime scene. There was no DNA. There was no fingerprints of value. You'll hear that there were shell casings all along the street, but you won't ever hear that these shell casings were linked to any particular gun or Shannon Stillwell or anything else. And there were no eyewitnesses on January 10, 2015 coming forward saying, yes, I was here and this is what I saw. And I saw this person do this. There was none of that. And you'll hear that this case remained unsolved. No one had been charged for 9 months and 9 days. On October 19, 2015, 9 months and 9 days after the Donovan Thomas shooting, a man named Nicholas Robinson was arrested on the streets of Atlanta and brought to Fulton County Jail for various pending charges. And you will hear evidence that Mr. Robinson decided he needed help. He didn't want to wear the Fulton County blue. You will hear that he contacted Atlanta Police Department and got in touch with Detective Thorpe. And Detective Thorpe came out and interviewed this Nicholas Robinson. You'll hear what Nicholas Robinson said in this interview, how he gave his vantage point to Detective Thorpe, how Nicholas Robinson said that he was seated at the MARTA bus bench right across McDaniel Street from the barber shops. And you'll hear that Nicholas Robinson told Detective Thorpe that he saw it all, that he saw the people that were inside the car. And he gave names. Nicholas Robinson said, I saw Antonio Sledge. He came out of the sunroof shooting. I saw Kenneth Copeland. He was in the front passenger seat. I saw Demetrion Garlington. He was the driver of this car. Cornelius Zachary, he wasn't there, but he supplied the gun to Antonio Sledge. And yes, I saw Shannon Stillwell, my client, in the back, passenger side, shooting a handler. So Detective Thorpe, after taking this information from Nicholas Robinson, who just broke the case, created photo lineups. And you'll learn what a photo lineup is. It's essentially 6 photos that contain a picture of a suspect and then 5 what we call fillers. And you'll learn about that. And Detective Thorpe showed these photo lineups. A photo lineup with Antonio Sledge, and then a photo lineup with Kenneth Copeland. Each person had their own photo lineup just to ensure that Nicholas Robinson could pick these people out of a photo lineup. And Nicholas Robinson did. And he signed his name, Nicholas Robinson, next to the picture of Antonio Sledge, and next to the picture of Kenneth Copeland, and next to the picture of Demetrian Garlington, and next to the picture of my client, Shannon Stillwell. Nicholas Robinson signed his name and said, these were the people in the car. Ladies and gentlemen, why am I telling you this? Well, Detective Thorpe had two small problems. First, you will see the surveillance video. You will be able to watch the surveillance video and the lighting conditions out there and the fact that there's gunfire going every which way and how fast the car is moving. And you will be able to judge, is it ever even believable that someone could see 4 people inside a car under those conditions? But there was a bigger problem that Detective Thorpe had. You'll learn that during this interview with Nicholas Robinson, it wasn't only Detective Thorpe, there was another investigator there, an investigator Gaither. And while Detective Thorpe was talking to Nicholas Robinson, Detective Gaither was doing some investigation of her own and looking into Nicholas Robinson and who this guy was who had just been arrested. And after Nicholas Robinson picked out all these people, including my client, Detective Gaither had to tell Detective Thorpe a little secret. Detective Gaither had to tell Detective Thorpe, that guy in there just signed those photo lineups that just signed their case, his name isn't really Nicholas Robinson. He lied to us about his name. His name is actually Spencer Wright. So, the case was solved by someone who lied about their name. So, what was Detective Thorpe's solution? Well, this is what the evidence was showing. Detective Thorpe completely overlooked the lie about the improbability of a man spotting 4 different individuals in the car moving at a high rate of speed in the middle of the night. He overlooked those things. And he said to Nicholas Robinson, or said to Spencer Wright, I've come to learn that your name is not actually Nicholas Robinson, it's Spencer Wright. Could you look at these photo lineups again? And instead of writing a fake name, Nicholas Robinson, could you actually sign your real name, Spencer Wright? And Spencer Wright did. So what happened? Detective Thorpe on October 19th, 2015, based on the word of Spencer Wright, the man who had just claimed to be Nicholas Robinson, Detective Thorpe took out warrants for Antonio Sledge, Demetrian Garlington, Kenneth Copeland, and my client, Shannon Stillwell, based on what Spencer Wright said. Okay. Since October 19th of 2015, people have had an opportunity to review some things on this case. The surveillance video that you will see, it's interesting because not only does it show McDaniel Street, which catch the incident, but it also shows the Marta park bench right across from the barber shops on McDaniel Street. And know who's in the know who's in the park bench? The bus, Marta bench, across from the barber shop? No one. It was all fabricated. It was all made up. It was all a lie. We've been able to review Spencer Wright's jail phone calls to associates made around that time. All but admitting, I'm lying. I need to get out of here. I'm inserting myself into a case so I can get favorable treatment, so that others get arrested. The state has since dismissed the charges against Antonio Sledge, Kenneth Copeland, and Demekion Garlington. They continue to push forward against Shannon Stillwell. Why is Spencer Wright so important? Why have I spent so much time talking about someone who clearly lied, who clearly wasn't there, who clearly made things up? Well, Spencer Wright gives us the blueprint. He tells us what to look out for. What was Spencer Wright wearing when he fabricated his story? Fulton County blue. What did he want? What was he in search of when he fabricated his story? Control of his destiny. He didn't want it to be left in the judicial system. He wanted to use something to get a deal. He wanted to take back control. That's what men in blue do. Okay. In this case, I anticipate the state will bring 4 witnesses forward. All 4 have certain things in common, as I stated. When they supposedly came upon information that was relevant, never shared it with law enforcement. But once they were wearing blue and they needed something, that's when they came up with their stories. I anticipate the state will call Quindarius Zachary, ironically, one of the people accused by Spencer Wright. You'll learn that he claims he knew information from January 10, 2015. January, February, March, April, May, never shared this information with anyone. But lo and behold, you'll hear he was found himself in custody for serious charges on August 5th of 2015. Then all of a sudden he had a story to tell. You'll hear he gave a second statement to law enforcement approximately a year later, where he was in a room with the gang investigators, with prosecutors, including the prosecutors that were handling his case and had control over his destiny, his future, and his attorney. And you'll hear that he gave a second statement and was looking for a deal. Quindarius Zachary is no longer wearing blue. Quindarius Zachary is not charged in this case. He got his deal. You'll hear about Kenneth Copeland. Again, someone ironically accused by Spencer Wright. You'll hear that Kenneth Copeland hates jail more than anything. The problem is, for someone that hates jail more than anything, he does a horrible job of avoiding it. And you'll hear that throughout this investigation, he's repeatedly arrested by Atlanta Police Department and other jurisdictions. And you'll hear 2 of those arrests were on June 10th of 2015 for guns, found in possession of guns. October 28, 2021, guns, found in possession of guns. And he makes it very clear about what he thinks about wearing the blue. But the interesting thing about him is, as you will hear, is every time he's arrested, law enforcement runs out to talk to him. And he goes through the same song and dance about how they'll do anything. Just don't don't make me wear that blue. Kenneth Copeland is no longer wearing blue. And he's not charged in this case. I anticipate you may hear from a man named Sammy Davis, who claims he was at the scene on January 10, 2015. January through December 2015, never once went to law enforcement. 2016, never once went to law enforcement. But then in March 17, 2017, when he's in jail, wearing blue, law enforcement comes out and talks to him. You'll hear his story. His story about how two cars were driving down McDaniel Street, and the first car sent a signal to the second car saying, Donovan Thomas is just leaving the barber shop, as a signal like it's time to shoot. And how the second car pulled up in front of the barber shop and stopped in the middle of the street. Just stopped. And then people started shooting at Donovan Thomas. You'll hear Sammy Davis' story. You'll also see the video. You'll see that there's no first car, second car. You'll see that there's no signal. You'll see that Donovan Thomas wasn't just leaving the barber shop, that he had, in fact, like the state had already stated, been hanging out with friends in that parking lot for quite some time prior to the shooting. And most importantly, you'll hear, or you'll see on the video, that Sammy Davis's claims that his car stopped are 100% wrong. The car never stops. The car drives on by. Bullets flying everywhere. You'll be able to listen to Sammy Davis's story and compare it to the surveillance video to figure out how much value you should give his story. And finally, I anticipate you may hear from a man named Tremont Stillwell. A man who curiously claims he's my client's uncle. Not sure what that's about. You'll hear that he claimed to come across important information in January of 2015. And he claimed he came across this important information while talking to someone with his wife, Vanetta Guffey, right there. You'll hear throughout all of 2015, never said a word to law enforcement. Wasn't until March 22nd, 2016. Guess what color Tremont Stillwell was wearing at that time? You got it. When he was in jail for serious charges and he needed help. He needed help from law enforcement to start to reclaim his destiny, control over his life, to escape the monotony and the filth of the Fulton County Jail. And you'll hear that he claimed to have information. You'll hear that the state, to their credit, went to try to corroborate whatever Tremont Stillwell was talking about and talked to his wife, who is now deceased. Her name is Vanetta Guffey. She's now deceased. But you'll hear that she was interviewed on May 11th of 2016 when she was still alive. And you'll hear what she had to say about Tremont Stillwell's claims. That what he's saying happened, never happened, A, and that Tremont Stillwell is a effing liar. Those are the state's witnesses in this case. Those are the men in blue. Count 2 of this indictment is the count that charges my client, Shannon Stillwell, along with a whole new group of individuals with the murder of Donovan Thomas. There will be no forensic evidence, there will be no ballistic evidence. There will be no eyewitnesses that presented themselves at the scene to say, I saw this occur. The surveillance video will not give insight as to whether Shannon Stillwell was there or not. The state case will rest entirely on the word of men in blue. When the evidence is done and trial is done in this case, I'm going to ask that you return a verdict of not guilty to count 2, murder. Okay. Hold on one second, Shane. Now, I would like to preview a little bit about my client's life after the Donovan Thomas murder. Remember, on October 19th, 2015, the Atlanta Police Department, Detective Thornton, and the news broadcast to the world, and more specifically to the streets, and more specifically to the Inglewood family blood gang that Donovan Thomas was the head of, that my client was responsible. Based on the word of Spencer Wright, based on the word of someone that even the state is saying lied. First they said wasn't completely accurate. No, it was lied. Based on that, they broadcast to everyone that my client was responsible. And there has been repercussions. You'll hear in 2015, people pulled up to my client as he stood outside his store, shot a gun at his head, and grazed his forehead. Thankfully, he's still with us. You'll hear that later in 2015, my client went to go get a fish dinner with the mother of his child and another young lady named Tiara Jones at JJ's Fish at the corner of University and Pryor. And members of the gang spotted them there, stalked that car, drove behind the car, and unleashed bullets upon that car, hitting that poor lady, the driver, Tiara Jones, in the face, killing her, causing the car to crash and spin, breaking bones in my client's body, collapsing his lungs. The streets have not cared that Spencer Wright is a liar. Since that time, my client's life is changed in some small ways and some big ways that I think make sense. Shannon Stillwell, since that time, has been careful about his surroundings. He tends to back into parking spots. He tends to run red lights at intersections, not to be a sitting duck for IF gang members or anyone else. He habitually changes residences. And yes, he does habitually rent cars, including a white Audi. He does this, the evidence will show, so no one can associate him with any particular car. None of the IF gang members can know where he is. And yes, when he rents cars, he does tint their windows, so no one can see in. That's the life he leads since 2015. And yes, when he leaves the house late at night, he does conceal his identity. It was during COVID, but he does wear a mask. That's been Shannon Stillwell's life since 2015. And I'm going to ask that you keep that into account as you consider the evidence as it's presented. Now, 7 years later, March 14, 2022, remember, Shannon has been publicly accused, but no one has ever taken that case to court. No one has ever even tried to actually prove the case. They just accused the case. And Shannon has remained a wanted man. Not by the police, but by someone scarier. On March 14, 2022, the evidence will show that Shannon, Quamarvius Nichols, Nikion Garlington, and Miles Farley were planning on going to the music studio to work on music. Still chasing Andrew. The evidence will show that Mr. Garlington was a passenger in Mr. Stillwell's and Shannon's rented white Audi with tinted windows. And Mr. Nichols was with Mr. Farley in Mr. Nichols' white Ford Fusion. the evidence, and you'll see, in this case, you'll see there's several different surveillance videos that you'll see in this case. The first being the BP footage. That's from the BP at the corner of Fulton Street and Windsor Street in Atlanta. And you'll see the video. And you'll see Mr. Stillwell. No, we will never deny that he was at the BP. We will never deny that. We'll never deny that he was in a rented white Audi. And you'll see Mr. Stillwell pull up on that camera and back into a parking spot right in front of the BP. And you will see Mr. Nichols shortly thereafter in his white Ford Fusion pull up at the gas tank so he can purchase gas to get to the studio. You'll see footage from inside of the store. That's Mr. Nichols. You'll find out that that's Mr. Nichols purchasing an item, and that's Mr. Stillwell, my client, wearing a Pink Floyd hoodie with a pink wool cap on. And you'll be able to observe them on video, and you'll see Miles Farley, a third person in their group, a shorter individual, come in, and you'll see them playing around and pushing each other in a playful manner as friends do. I'm going to ask you to observe them on a video and ask yourself, does that appear to be men on a mission? Or does it appear to be friends just planning on going to the studio? The video will reveal that at some point, a gentleman by the name of Shamal Drinks pulls up in a red car at another, and in fact, I believe that's a picture of it right there at that gas pump, and he enters the store. You'll be able to see the video of him entering the store from the parking lot, and you'll be able to see him inside the store. You'll see that he gets into some sort of argument or altercation, not an altercation, an argument. It appears with the clerk, and he leaves the store, and he gets in his car. There will be no interaction whatsoever between Mr. Drinks and my client. And you'll be able to watch the FedEx footage on Windsor Street, which will show these cars drive up and end up at a red light. You will see my client's car, white Audi, run a red light. You will see Mr. Nichols follow my client's car and run a red light. Eventually, cars come in to replace him, and traffic flow continues and continues for several minutes. And eventually, a man who's just happened to be going the other way looks into Mr. Drinks' car, which is still sitting there, and notices that Mr. Drinks has been shot. What you will not see on this video is any indication at all that this shooting occurred while my client's car was beside Mr. Drinks. You will not see any muzzle flash, you will not see any commotion, you will not see any fight, you will not see anything at all that suggests that that's when the shooting occurred. So this March 14, 2022 case, what I anticipate is you will not hear any eyewitnesses say that Shannon Stillwell, and let's be clear, the state is accusing Shannon Stillwell. I mentioned that there's 4 people to this party. They are accusing Shannon Stillwell of shooting Mr. Drinks out of that white Audi. The state will not present to you any witnesses that saw this occur. The state will not present to you any forensic evidence that proves that this occurred. The surveillance I submit to you, and you'll be able to see it and judge for yourself, points to the exact opposite, that the shots did not come from Mr. Stillwell's car, nor did, and I'm not suggesting they came from Mr. Nichols either, they came from neither car. So why was Shannon Stillwell arrested? Well, they had video of Shannon at the BP. Okay, that's fine, we don't deny that, never will. They made certain assumptions about what would be on that FedEx video that you will be able to look at and determine what it shows and what it doesn't show. And I'm sure they assumed that it would show some shooting, but it doesn't. And finally, they made assumptions about Shannon Stillwell. Remember what the state said in opening about how Detective Hogan had his case. He had people on a video at the VP, which is near where the shooting occurred, but not where the shooting occurred. He had people on this video, and then he talked to another detective, Viverito, and Viverito said, "Oh, that's Shannon Stillwell. That's Shannon Stillwell. Oh, that's Marcus Nichols." And they just ran with it. Yeah. Shannon Stillwell was at the BP that night. He didn't shoot Shamal Drinks. None of his friends shot Shamal Drinks. They went to the studio. Since these warrants were taken out for Shannon Stillwell, and I'll tell you the warrants were taken out and Shannon Stillwell was arrested in that same white Audi on March 17th, 2022, 3 days later. Since those warrants have been taken out, some other information has come forward. First, I'm going to ask you, and you will, this will be entered into evidence, I'm going to ask that you consider the rental agreement for the white Audi. You will learn that on March 16th, 2 days after this alleged shooting, when every other person who has a guilty conscience, anyone who has a guilty conscience is trying to get out of the rental car, Shannon extended his lease. I'm going to ask you to consider and really think about that. Extending a lease of a car that you supposedly just killed someone. Are those the actions of someone who's guilty of that crime? You're going to hear about the wiretap on Demekion Garlington's phone. Remember, Demekion Garlington was in Mr. Stillwell's car. And the state hinted at it a little bit. They were talking about Jaden Myrick and people wanting to attack a man named Lucci. And based on these concerns in the jail, the state applied for it, and you'll learn what a wiretap is. They applied for a wiretap and received a wiretap for Demekion Garlington's phone. The phone of the person who was with Shannon Stillwell on March 14, 2022. And you'll learn what a wiretap is and how a wiretap really consists of law enforcement sitting and listening in on all your phone calls, incoming and outgoing, and recording all the relevant and pertinent phone calls and conversations that occur. You'll learn that this wiretap on Demekion Garlington's phone began on March 10th, but certainly well before March 14th, the date of the Shamal Drink shoot. So it was in place that night. Who knows about the wiretap? You'll learn that too. Do you think the government tells you that your phone is being wiretapped? Of course they don't. It's secret. No one knows. That's the point. And you'll learn about who Demekion Garlington is and what type of guy he is. I would submit, if you have a secret, you wouldn't want to tell Demekion Garlington. You'll hear him on the wiretap, drunk, high, talking about everything under the sun. Pills, weed, guns, girls, robberies, all stuff that he's involved in, completely against his interests to discuss, but he doesn't know he's being listened to now. But one thing that's interesting, of all the things that this loudmouth talks about, all the crimes, and they said they bragged about this stuff. They said Demekion Garlington was bragging about this stuff. All the things they brag about, no, it never comes up. Shooting anyone on March 14, 2022. All the crimes he discusses, that never comes up. Finally, and most importantly, the science about this March 14, 2022 case. We're going to learn about gunshot residue. Gunshot residue testing that tests for microscopic particles that contain a combination of lead, barium, and antimony. Particles that come from the explosion of a gun and the gunshot primer that causes it. Synonymous with a firearm that has been fired. Who does gunshot residue testing? Georgia Bureau of Investigation, APD, all sorts of agencies to build cases against defendants. You'll learn how gunshot residue is collected. How you take a surface or a body part or an object, you take these adhesive stubs, these official gunshot residue kits, and you dab the surface of an item as much as you want. You can use multiple stubs. And then you take these stubs and you place them under an electron microscope. And a scientist can look under this microscope and see if there's any particles of gunshot residue that are on said item. You'll hear that Shannon Stillwell was arrested on March 17th in that same white Audi that he was in on the 14th. And you will hear that the crime scene technicians, in this case, made a specific decision to pick the best place on a car to test for gunshot residue. When the gun is fired, the gunshot residue would plume upwards. And so they take the best part of the car, the headliner. And for all of you that don't know what the headliner is, that's the cloth top of the car. That's pictured right there. You'll hear about Alexander Coven, a scientist, a man that searches the truth, a man who works for GBI, not for me, not for Shannon Stillwell. And you'll hear how that headliner that was collected from that white Audi on March 17th was brought to Alexander Coven at the Georgia Bureau of Investigation. You'll hear he's an expert in gunshot residue collection and analysis and detection. And you'll hear how Mr. Coven, as he was trained, took that gunshot residue kit, and took those adhesive tabs and dabbed that headliner again and again and again and again and again and again. Dozens of times. And then he wanted to make sure what he did was sufficient. So he took a second tab, adhesive tab, a fresh one, and continued to dab that headliner again and again and again and again and again to pick up any particles that would be on the headliner from that white Audi. And he took those tabs, those adhesive tabs, and he put them under his microscope that he uses when he's building cases for the state. And he looked at those tabs under that microscope for any particle of gunshot residue, any at all. Looking for 15, 10, 5, 3, 1, whatever he could see. And you'll hear that on June 3rd, 2022, 77 days after the state, after Detective Hogan, Investigator Rico, and the state made their decision that Shannon Jackson fired a gun, Shannon Stillwell fired a gun from that white Audi. 77 days after they made that decision, you'll hear that scientist Coven released his report. And on that headliner, there was not a single, zero gunshot residue to be found. That's the science. Ladies and gentlemen, regarding the March 14, 2022 case, the state has made 5 charges, 5 different counts against Shannon Stillwell, my client. First is count 49 on this indictment. It is murder, alleging that he shot out of the White Audi, he shot Shamal Drinks. The science belies those accusations. I'm going to ask you to find Shannon Stillwell not guilty of that count. Now, count 50 and 51 deal with violations of the Criminal Street Gang Activity Act, and they are essentially charges that say that Mr. Stillwell committed murder to further the interests of YSL, and he committed murder on behalf of YSL for the purposes of increasing his standing within the gang. Y'all are smart people. Obviously, I don't need to say it, but it'll make me feel better if I say it. If he's not guilty of count 49 murder, he cannot be guilty of count 50, and he cannot be guilty of count 51. Counts 52 and 54 similarly charge Shannon Stillwell with possession of a firearm by a convicted felon on March 14th of 2022 on the belief that he used a firearm to kill Shamal Drinks. If the state does not prove that case beyond a reasonable doubt, he cannot be found guilty of count 52. And count 54 charges Shannon Stillwell with possession of a firearm during the commission of a felony, that felony being murder. Obviously, if he didn't commit the murder, then he cannot be in possession of a firearm during the commission of said felony. In conclusion, my client has been charged with 2 separate murders. He's been wrongfully accused of 2 separate murders, and we plead absolutely not guilty. He's been charged with conspiracy to violate the Rico Act. And while now he has sold marijuana in the past, those were his decisions for his benefit and had nothing to do with YSL or anyone else involved in this case. He's pled guilty to those charges. He's done his time. That makes him an ex-drug dealer. It doesn't make him a conspirator. It doesn't make him guilty of violating any RICO acts. The ground rules. Shannon Stillwell is presumed innocent. The state bears the burden of proof, and the standard of proof is beyond a reasonable doubt. I believe in this case, if you focus on where the state's evidence comes from, you will find that primarily it comes from the stories of men wearing blue. I'm going to ask you to focus on things like science instead of stories. Compare the credibility of a scientist like GBI scientist Cole, who followed all the rules and determined there was absolutely 0 gunshot residue in that outfit. Compare that to what the state presents. Spencer Wright, who said his name was Nicholas Robinson, who lied, get out of jail. Spencer Wright duped Detective Thorpe on October 19th of 2015, and that is on Detective Thorpe. I am going to do my best to make sure that the truth comes out in this case. Make sure that no one wearing blue will be able to dupe anyone during this trial. My client, Shannon Stillwell, is not guilty. Thank you very much.
Ladies and gentlemen, how you doing? It's 5:30. All right, consistent with my earlier promises to you, I think it might be a natural stopping point for us to put a pin in today. and for us to come back to more, unless you all object to my suggestion. Hearing no objection, I think we're going to go ahead and do that. So let's go ahead and kind of review a couple of things to begin with. All right, first thing is when you go back into your headquarters jury deliberation room, dump your notepads, okay? Hopefully everybody's written their name in the inside cover of those freaking ones like I told you earlier. But if you haven't done so, go ahead and do so. Take a juror sticker and put it in your pocket, your purse, or whatever carrier device you have, so that when you come back in tomorrow morning, we'll go ahead and you can put that on as soon as you get into as you come in through the being screened in the courthouse, okay? All right. You kind of figured out already for tomorrow if you need, and I think I mentioned to you this earlier, a lot of you wearing jackets and everything else, it's easier, like I said, for you to put on a jacket or for you to take off something than it is for me to kind of regulate the temperature. So please bring whatever it is that'll make you comfortable tomorrow, your jacket or otherwise. Okay, that's kind of the administrator. And if you're running late tomorrow, as I mentioned earlier, let Ms. Umana know. But remember, I can't start until I've accounted for all 18 of you. So it's very important you, again, as I mentioned earlier, only you know how long it takes for you to get down here to Fulton County from wherever you live in our great county. So just plan accordingly, leave a little bit earlier. It's always easier for you to sit back there and just kind of relax and don't be so stressed than it is for you to kind of leave late, and that just kind of just puts you in kind of a position that you probably are stressed already when you get here. So I'd advise you to do that. Okay, you remember all my ad nauseam admonitions? They still apply, okay? So, very important. I mean, that you not talk about the case amongst each other as you're walking out. Do not talk about the case as you're in your headquarters jury deliberation room. Don't go on any social media sites. Do not let anybody friend you. Do not do any of the other things that I've told you earlier, like research anything, go by any scenes, take any photographs, or otherwise try and educate yourself to some things that you may have heard in the courtroom today. Remember, the only things you can consider are what's lawfully presented within the four walls of this courtroom. So it's very important that you consider and keep the court's admonitions, which I know you will continue to do so. There's great temptation when you go home tonight. Hey, what happened in court? Well, I saw you on TV. Are you supposed to respond to that? No, you're not. And you can blame me. You can even tell them Judge Glenn will say for you not to do that, all right? Because remember, your doing that would affect, and if we found out about it, would affect our ability to have a fair trial, a just trial, lawful trial as to all parties. So please adhere to that admonition and all the others, okay? Remember, nobody's supposed to have any ancillary or incidental contact with you. If anybody tries to reach out to you, I need to know about it so you can tell Sergeant Ingram or any of my team if anybody should try and do so, okay? And consistent with my instructions when you were here before, we'll go ahead and get you squared away for those of you that are taking the shuttle and for those of you that need to make other alternative arrangements. We have just get with Sergeant Ingram. He'll go ahead and coordinate that for you, okay? All right, so you're probably wondering, what time are we going to start tomorrow morning? I need you all here to be here by 10 o'clock, okay? We will start somewhere between 10 and 10:30 tomorrow morning, and I'll do that, try and give that to you every single night that we conclude, tell you what time in the morning you need to come to be here. That's your target or mark time you need to be here in the morning. Try and get here a little bit earlier because then, like I said, you'll be a whole lot more at peace. And then as soon as at 10 o'clock or thereabouts, I can find out if all 18 of you are here and I don't have to look for anybody. And then I can go ahead and we can get started once we're ready to pick up from where we left off from today. Okay, so 1,000 hours tomorrow, you need to be in your headquarters. Okay, I think I've gone through all the things I need to with you. Any ministerial inquiry of me at this point in time, ladies and gentlemen? Anything from me? Questions? None? Okay. Ladies and gentlemen, thank you for your patience with us. And as I mentioned earlier, and I mentioned through this entirety of the process, the patience that you've given us are giving us today and will continue to give us throughout the consideration of this matter. So unless you have any other query or questions for me, I will release you until tomorrow morning and bid you comfort. And we'll see you in the morning. We'll start up when you all get here at 1000 hours. Okay? All right. So with that, ladies and gentlemen, have a good evening. All rise.
Miss Hagerty and Mr. I made eye contact with you and asked you, please stop talking during all that. Please don't do it. Yeah, just all of this. I would.
Okay, ladies and gentlemen, please be seated. Our jury has left us and the door is closed. All right. So, councils, tomorrow morning, first, before I go ahead and set the time for you all to be here tomorrow morning, Mr. Harvey, sir, have you talked with counsel for your client? Your client's spouse, I should say.
No, I haven't, and I will try to contact her. She was flying back in after the holiday, so I didn't try to contact her. I'm going to do that right now.
If you could ask her to be present for at minimum 9:45-ish tomorrow morning, I'll take it up somewhere between the 9:45 and 10 o'clock time period, and I can go ahead and get that done, or you can have a conversation with the state, and I can final that particular ruling, okay?
Yes, sir.
All right, okay. So councils, if you all could be here tomorrow morning for approximately 9:30, and as I told our jurors, as soon as all of them are accounted for and we take up that last issue, then we'll go ahead and get started. What questions do you have of me? Anybody?
On behalf of Mr. Williams.
Okay, so Mr. Steele, you have yet to make an opening statement, is that correct?
Correct.
All right. Mr. Matthews, you have not made an opening statement as of yet? Ms. D. Williams, you have not made an opening statement as of yet, is that correct? All right, is there anybody else that I have not taken into account already?
My fault.
I'm sorry?
My fault.
It's just going out, that's all. You know.
Yeah, that's not.
Yeah, it's kind of giving up on me today. I don't know what's happened to it, but yeah. Anyways, Mr. App? Okay, all right. So we'll start tomorrow with that, and we anticipate after we complete opening statements, stating you're prepared to call your first witness?
Yes.
Okay. All right. Any other inquiry of me at this point in time? Okay, hearing none then, folks. Appreciate your patience and diligence. I'll see you all tomorrow morning for an anticipated 10 o'clock start time. Please try and be here by 9:30, and then we'll go ahead and I'll take up Mr. Harvey's matter, and we'll go ahead and get started, okay? All right, we're in recess.
Thank you, Your Honor.
You're welcome.
Oh my God. How boring was that? I'm usually got old people on board. Okay. I think you were right, and I didn't realize that, Grandma. there is 4 or 5 defendants there. Now, I swear last week it was only Thug and the other guy. So why are they saying this is just Young Thug's trial, Rico trial, when all those other guys are there? Yeah, that's crazy. See, I thought other ones already had their hearing, but I guess I'm wrong. It happens, people. It happens. But Grandma and baby, I want to thank you so much for being here. I appreciate you. And I'm probably going to go live later. Again. A couple times, actually. I got to expose somebody. Even more so. Committed some crimes. Hurt some people. Can't be having that. Okay? Okay. All right. Thank you.